What's the difference between DWI and DUI? If you've heard the terms DWI and DUI, you might wonder whether they mean the same thing or signify very different offenses. While the distinction varies across jurisdictions, understanding these terms is critical for navigating legal challenges and staying informed about your rights. Defining DWI and DUI. What is a DWI? DWI stands for driving while intoxicated. It typically refers to operating a motor vehicle in a public place with a blood alcohol concentration, or BAC, above the legal limit, or while not having one's normal mental or physical faculties due to the introduction of drugs or alcohol. In Texas, the legal per se BAC limit is 0.08% for drivers aged 21 and older. Zero tolerance for minors. Any detectable alcohol for drivers under 21 is any amount. Commercial drivers, there's a stricter limit of 0.04% which applies. DWI also includes impairment by prescription drugs, over-the-counter medications, or any other substance capable of causing intoxication. What is DUI? DUI stands for driving under the influence. While often used interchangeably with DWI, DUI in Texas usually refers to minors operating a vehicle under the influence of alcohol or drugs, regardless of the BAC. Offenses with less impairment than a standard DWI in some jurisdictions, potentially. In Texas, DUI is specifically a charge for individuals under 21 who are caught driving with any measurable amount of alcohol in their system. So how do DWI and DUI differ by state? Well, in Texas, the terms DWI and DUI are distinct, separate offenses. DWI applies to drivers 21 or older operating a motor vehicle in a public place while intoxicated. People under 21 can also be charged with driving while intoxicated. DUI, however, generally applies for any drivers under 21 with any trace of alcohol. Penalties for DUI are generally less severe than DWI, reflecting lower BAC thresholds and age-specific focus. In other states, while I am only licensed to practice law in the state of Texas, I'm aware that in some states, DWI and DUI can be used interchangeably, while others define them differently. For example, in New York, they use the term DWI for alcohol-related offenses and DWAI, driving while ability impaired, for lesser impairments, including drug-related cases. In California, they only use the term DUI, covering both alcohol and drug impairment. Florida, like California, uses DUI as the catch-all term for impaired driving. What are the differences in penalties between DWI and DUI? The penalties for DWI and DUI depend on several factors, including the offender's alleged BAC, prior offenses, and the presence of any aggravating circumstances. For example, causing an accident or having a minor individual in the car. Texas DWI penalties for your first offense: fines of up to $2,000, a license suspension of up to 2 years, and or up to 180 days in jail. A DWI second includes fines up to $4,000, up to 1 year in jail, and mandatory installation of an ignition interlock device if one is on community supervision. The interlock is required as a condition of bond pending the disposition of the criminal case, and that money adds up fast. Third offense. DWI third has fines of up to $10,000 and or 2 to 10 years in prison. Texas DUI penalties for drivers under 21 can include fines of up to $500, a license suspension up to 60 days, and mandatory community service ranging from 20 to 40 hours, which must be related to education about or prevention of alcohol misuse. For a more detailed explanation, see my post on DWI penalties in different states, a comparative overview. So why does this distinction matter? The difference between DWI and DUI can significantly impact legal outcomes. Here's why. The severity of charges. Number one, DWI charges carry heavier penalties than DUI charges in most jurisdictions, particularly for adults, and especially in Texas. What about the insurance consequences? A DWI conviction can lead to significantly higher insurance premiums than if one were to get a DUI or nothing at all. What about your criminal record? Understanding the specific charge helps in seeking appropriate legal representation and potential expungement opportunities. So, what about fighting your DWI or DUI charge? If you're charged with either DWI or DUI, an experienced criminal defense attorney near you can challenge the validity of evidence, such as BAC results and/or field sobriety tests, negotiate reduced charges or alternative sentencing, help you understand state-specific distinctions and how they apply to your case. So while DWI and DUI share similarities, their distinctions are vital for understanding the charges and penalties you may face. Whether you're dealing with a DWI or a DUI, having a skilled attorney on your side can make all the difference. If you or someone you know is facing DWI or DUI charges in Texas, contact us today for an expert criminal law legal representation.